please.
It's on now.
Yes, you can speak now.
Facebook
Yes.
now. It's on Facebook.
Yes, Bijindeji, you can talk now.
Okay. We all work hard all our life, and we always want to make ourselves secure and our children very secure and our loved ones. So it's very important that the hard work we have done, that our things that we have made for us and for our family are safe and they go in the safe hands. So one of the things we need to know is plan always, to know what we are going to do while we are alive, how we're going to use the money to make ourselves comfortable. But what happens if we are not there? Our loved ones, the children, the family, they are looked after. And that's why it's very important to have the will, and not only the will, but a lot of other things as well that we need to know. So we are very fortunate to have today with Asha Australia Foundation, Mithu Gopalan, who's our life member. Just to let you know, with Asha Australia Foundation, we're trying all the time new things for our community, our seniors, our members and supporters. We have daily Bollywood music program. We have yoga Zoom sessions weekly, Antashri, and every fortnight health and well-being meetings. And very soon we're going to start on the Saturday. We are not having our health and well-being meetings, mini concerts, and hopefully before New Year we'll have a big concert. So with all these little few words, I welcome Mithu, and we appreciate your ongoing support and your time. To you, Mithu.
Thank you, Bijindra Aunty, for having me, and thank you for the opportunity provided. I'm grateful. And good evening, everyone. Thank you for your patience and having waited this long, and having tuned in on this lovely long weekend, taking time away from your loved ones. We are grateful. So thank you so much. What I plan to do is obviously go through what Bijindra Aunty was saying. The most important things is in relation to wills, how do we best protect your assets, both here, overseas, and then also the commonly heard terminologies like power of attorney, guardianship, what does all that mean, financial manager being appointed, and things like that. So I will go through my presentation. I will take you through it all. And of course, at the end, if there are any questions, we welcome you to raise your hands or put your questions in the chat board, and I will be more than delighted to answer them. Now, of course, if we are running out of time, you're more than welcome to call me at any stage or email me, which I'll leave you with my contact details, and please reach out. And as I was previously asking a few of the invitees, how many of you have wills at the moment? And I think most of you were raising their hands, and I'm assuming most of you have wills, which is a great sign. So I'm pleased to see that, because obviously you've done the hard yards, you've worked all your life. Now is the time for you to rest, relax, enjoy, take it easy. So how do we actually protect your assets in the best possible manner, so that you know that it's actually being passed on to whoever you have nominated, rather than the government nominating the person to be? So let's go through it, and then I'll take you through it step by step. And then of course, if you have any questions, please do not hesitate to raise them at the end. Let me just share my screen. Please give me 2 seconds. Can everyone see this screen? Thank you. So the summary of my presentation, as I was explained to you before, will encapsulate wills, how to manage assets in India, or maybe any other countries as well. And most of you will be having assets here and overseas. So how do we actually best protect your assets? Then thirdly, power of attorney. That's a very common terminology that people come across in this day and age. What does that entail? And what does guardianship mean? Is that something that you've come across before? And obviously we'll touch a little on the elder abuse, because I was most impressed. I did attend the recent session that Asha actually showcased in relation to releasing the 2 amazing videos. And I would like to congratulate all the artists and actors and the creators and the people behind it and the brains behind it, because I found those 2 videos incredibly useful. And I would encourage you to pass it on to anyone and everyone that you would actually be liaising with, because you guys have done such a great job. So I congratulate Asha on that amazing videos, the 2 videos. and reflect, take the time to reflect back on the issue that we have to talk about, which is elder abuse and what are your legal rights. Okay, wills and estate planning. I'm sure most of you would have actually met with your financial advisors in conjunction with your tax consultants or accountants, and you would have mapped out your, future. How do we best, plan so that you can have the best tax advantage, or how do I best ensure that my valued assets are in fact given to the children or your loved ones as you nominate rather than someone else nominating. So what is estate planning? Estate planning is the process of anticipating and arranging during a person's life for the disposal of their estate. Obviously, you want to make sure your livelihood, like your earnings that you made through your life is given to someone who you nominate. That's what it's all about. And also, how do you best plan so that, for example, your super and what would be left after super, how do you want that to be transferred to the next generation or to your loved ones or whoever it may be? You might not want to give it to your immediate family because they're all doing okay and you nominate someone else overseas. All that is possible, but you need to be notifying it in an appropriate form. That's what we need to be looking into, so that uncertainties can be avoided. And also what most people do not realize is if you do not have a will, the threat that you face is you actually have to be applying to the Supreme Court of New South Wales in order to get a letter of administration. We lawyers call it LOA, but that is known as a letter of administration. So that is a Herculean process because you need to then put to the Supreme Court who your loved ones are, who your interested parties could be, who do you owe debts to, who could be other parties who would be interested in your estate. So you need to put all that. The Supreme Court will go through your list of assets, liabilities, then nominate your so-called administrator and then appoint a letter of administration. To avoid it all, we would always recommend that you have a will. You actually leave a will in order to outline your wishes for the next generation to follow through. Okay, so the estate planning involves wills, trusts, beneficiary designations, power of attorney, so on and so forth. So, and what does each one entail? That is what I'm going to be taking you through now. Most of you raised your hand, and which I'm very happy and pleased to see that you all have a will, but you need to be looking into the fact, how old is your will? What we would recommend is that you definitely look into your will if it's more than 10 years old. So because things change, needs change, your relationship with your people change. Some people must have passed away. People who you have bequeathed certain things to might have passed away, and you probably would have forgotten about it. So please look into your will. Please reread those wills to ensure that whoever you're leaving your assets to are still alive, are still with someone who you have a good relationship with, and you do want to be leaving it with, because the people get divorced, people remarry, so many things happen within the time stipulated that we from since the last will was done. So please look into that. The next question is, who should act as your executors? Again, that changes because when you probably did this will 10-15 years ago, you probably had nominated your son or your wife or someone else. And for whatever reason it is, maybe your son has moved overseas, or maybe your wife has passed away, or something must have happened. So please ensure that the executors, who are the people who in fact executes your will, that is why they're called executors, are in fact there. They are aware. They do know what's happening. They should have some idea of where your assets are. You might be keeping in touch with them. So what I usually advise my clients are to have two executors. One, someone obviously of your close family. So for example, it could be your partner. So if it's if the husband is making the will, he would put it to his wife as executor, and vice versa, the mirror wills. But I always recommend to have an independent party as a second executor. This is only because we lawyers see the other side, because after the parents pass away, the children, and more so the third parties, it's the partners and the daughter-in-laws and son-in-laws who actually bring in issues subsequently in relation to their estates and wanting more of the share and wanting more of their estate. And hence, if there is someone who actually is a third party, so for example, your accountant has known you for like past 20, 30 years, you can definitely nominate your accountant as a second executor. So he or she will be foreseeing what the other person is actually doing. So for example, if your son is nominated as the first executor and he's been following everything, but if your second son's wife is creating problems and she's saying, I don't believe what he's doing is right. He hasn't actually sold the house at the right time, and he actually undersold it, and we should have made more than 500,000. He's made a loss there. So at least if there's a third party there overseeing it all, who is independent, they will have a view to be providing. And so that is something that you can actually, will save you a lot of money according to what we advise. We lawyers definitely will recommend that there is a second independent executor appointed so that you guys are covered, your assets are protected, so that any confusion and issues that people raise in the future can be brought down to a minimum. What are the assets that will pass under your will? Definitely anything and everything that you're talking about, like, in your asset pool. Of course, what it won't include is superannuation funds, because that's separate. The minute someone passes away, super kicks in separately and independently. That will be separate, and also life insurance. That's also separate. So those two kicks in immediately when someone passes away. So the parties do not have to wait, or the loved ones do not have to wait until they file for a probate, get an order from the Supreme Court, then go and unfreeze the bank accounts and get things going. So what usually happens, just so that I fill in people about the word, what probate is, what does probate mean, is when someone passes away and you have left a will behind, it's not as simple as going and executing the will. What we have to do, the person who is left behind will have to, and obviously who is nominated as executor, has to take your original will, go to Supreme Court, register that with the probate application form, fill in all your assets and liabilities, put that in a schedule, put in all the interested parties' details, submit it to the Supreme Court saying, where are all the bank assets, bank accounts, where are all the other assets, what does it all entail, what is the total amount, what does it all incorporate? Once the Supreme Court looks into all that is when a probate certificate will be granted and issued to the executor. It's only after that probate is issued can the executor proceed to enforce the will. So there is a process, and that takes at least good 4 to 5 months subsequent to someone passing away, because obviously you need to get the death certificate, you need to notify all the banks, all your accounts are frozen. So there's a lot of things to be followed through. You've got to make sure that you're actually leaving everything as precise as you can, so that there are less headaches for your children to be following through, because obviously you've all worked hard and there's lots of assets that you've built, but how are you leaving it as headache free for your children? That is what you're thinking about. So coming back to our questions, what are the assets and financial resources that you own? You do not need to disclose all that in its entirety and detail to the lawyers, of course, unless of course you need to be specifying, for example, I need my investment property in Coogee to be given to my first son, and the property in Queensland to be bequeathed by the second son, and my daughter to get a property. Then of course you can say that. Otherwise you can leave it as a general pool, saying that I want everything to be put in as one lump sum asset pool, and then divided equally between the 2 kids or 3 kids or 4 kids that I have. And that obviously saves a lot of hassles, when you look at it on the face value often, because obviously there are less issues. One child says, oh, I wasn't left with this, and that's not fair because property in Coogee can get more return as opposed to property in Queensland. So things like that. So what we then advise our clients is best is to put it in a pool, put it all together. The executor will meet with the children at that stage and say, look, this is what the will says. I'm told to be selling it all in order to divide it equally, and the children are given a choice as to whether they want to actually keep one property each, or do they still want to follow through. So that way it's a little easier for the executor to follow things through. So in essence, you do not have to specify it unless, of course, you want to specifically give something to a certain child. And of course, there are mothers who come to us and then say, I want the specific Kundan set or Kashi set to be given to my daughter-in-law or my granddaughter, and this set, the ruby set to be given, and that's also fine. Then we attach photographs of those jewelry sets to be attached with the will, and then we say, oh, specifically to be bequeathed to this granddaughter or daughter-in-law, whoever, daughter or whatever. Are there any family members who need special consideration? So for example, we see this all the time. So like, when you do a will when you're 40, obviously your children are still growing, and then they come back to us when they are 60 or 70, by which stage someone must have met with a car accident, and he or she will not be in a position to be earning in the same earning capacity as the other children. So then the parents revisit their will and say, look, I want to be giving a bit more to that son of mine who's now not in a position to be earning as much as the other children are earning. They're all doing much better than that child. So I wish to be leaving more for this child, and which is fine. But we then make specific notes. We then added, we leave specific instructions so that, if in case this gets challenged in the future, we have our notes to say that this is what the person really intended to do, and this was his or her intention, specific instructions provided considering the special situation. So that's something that you can look into. And for example, when you're leaving someone behind, when one person is actually bedridden and the other partner comes in and says, God forbid, if something happens to me and she's bedridden at the moment, I do not want her to be taking on all that responsibility. So this is what I'm doing. And I want to make sure part of my estate, which otherwise was set aside for my kids, have to be given to my wife at the moment. So whatever the reasons are, we actually stipulate that, we leave as appropriate notes to that effect, with the intention that if future proceedings are commenced in the Supreme Court pursuant to the family provisions claim, which the family members are entitled to, and they do it very often these days, we can cover your intentions. So the testator's intention is clearly specified in our notes so that we actually produce that to the court, and then the court gets to know, or a judge gets to know what exactly the testator had intended. The next question is, how can the tax position of your estate and beneficiaries best be managed? That we usually recommend our clients to go meet with their accountants, because obviously we do not have the expertise, and we do not give advice to that effect. But that is something that we would definitely recommend that each one of you speak with your financial advisors or tax accountant in order to ensure that, because obviously you've got a lot of assets at this stage of your life, and you want to make sure how you minimize it all and how can you streamline it to the best of anyone's abilities. So that's something that we definitely recommend, because that's where the family trust kicks in. How can you actually ensure that the money is passed on to the grandchildren, for example, if there's a family business, so on and so forth. So it actually varies according to case by case basis, and then we recommend you to meet with an accountant and take it from there. Last question, how is a will done? Obviously, you can do it by yourself. There is nothing saying that you should be meeting with a lawyer to get it done. You get a will kit from the Australia Post, and you can do that. But obviously, as assets grow and as family grows, as everyone knows, that's when complications arises as well. So, for those reasons, in order to ensure that future generations do not actually question this in any manner, we definitely recommend you meet with a lawyer in order to ensure that all I's are dotted and T's are crossed, so that a will cannot be contested in the future. And that's the whole point. And to ensure that your hard-earned money doesn't get dissipated on lawyers arguing about your estate and what your intentions were 5 years down the track. So whenever someone brings a claim, and that's what it's all about. Okay, so we've spoken about what a will is. Will is a legal document that sets out what your intentions are. So for example, whatever it is your assets are, when you pass away, will kicks in. Until you pass away is all other documents that we will talk about later, power of attorney, guardianship, all that works until you are alive. The minute someone passes away is when a will kicks in. So people usually get confused. I've got a power of attorney, so is that fine? Or I've authorized this person to be my attorney, so I don't think I need my will because my son will take care of it. No, these are two distinct, separate documents. So you definitely need to have a will, which is independent of a power of attorney, independent of an enduring guardianship or financial management. Again, we've also touched base on the other issue that I was talking about. If you die without a will, which is called, we lawyers call it, a terminology is intestate, your estate will be distributed according to a predetermined formula, with certain family members receiving a defined percentage of your assets, despite what you may have wished. So for example, if you have been estranged from your stepdaughter or daughter, or something has happened and you really did not intend for that person to be receiving anything of your asset pool, he or she will still get it, because this goes to court straight away, because that's what I was touched base on at the beginning of my segment, which is the letter of administration. That is when what happens when someone dies without a will. Okay, what is an executor? Executor is a person who you appoint and nominate to be following through the will and to make sure that he or she executes your wishes in every way. That is pretty much what it is. An executor executes your wishes and follows through what you have written in a will. So he or she will be told, yep, all of my assets have to be collated, distributed between my 5 children. So that's his or her headache to do it. So obviously the ideal scenario would be like, your own children that you appointed. So, they'll do it without any issue. But if, for example, you do not have any children in Australia, or one child is overseas and cannot come here, I always recommend to have someone here in Australia, because it makes their life a lot easier to run around, to liaise with the banks here and to liaise with any other entities that you have assets invested with. So that makes life a lot easier. So, and also get their permission. If obviously they're not willing to do it, there's no point appointing them. Get their permission, have a chat with them, and then before you outline them and list them in your will. And the role of the executor is to manage the estate within the terms of the will and protect the assets of the estate. A trustee looks after the ongoing bequests to the family and friends for a specific time stated in the will. For example, a trust for your children or grandchildren. So what happens is, if you've got 6 grandchildren and you've set up a trust in your will, you can say, this executor is appointed in order to take care of all my assets, collate them, distributed between the 5 children, but I've got 10 grandchildren, and I appoint so-and-so as trustee to be nominated as their grandchildren's funds account for the education for the next 10 years until all my grandchildren finish schooling or whatever it is. So different people have different needs. So that is the difference between an executor and trustee referred to in the will. What makes a will valid? Obviously, you have to be over the age of 18. And the will has to be signed by the person making the will. So that is something that I can't insist enough, because we've spent numerous days in court arguing about whether a will is in fact original will or not. So I insist that people sign in blue ink, because we have had issues where we could not actually establish in court whether the original will was in fact original. We had to have a handwriting expert, because the dent at the back side of the paper wasn't high enough to ensure whether it was original or not. So that's the level and extent that the Supreme Court looks into. So they look into that, and then so to avoid that, I always say, please sign in blue. You must be aware of you must have the testamentary capacity. That's another important thing. So for example, if you know of someone who is not mentally totally with it at the moment, and he or she wants to change a will, it becomes very hard. And as most of you are doctors in this group, you would know about the issue of mental capacity. We lawyers have to insist that they go and speak with their GP or whoever the treating doctors are, to ensure that they actually get a certificate from them, because otherwise the buck comes back to us. To ensure that why did I take instructions from someone when I knew he or she did not have the mental capacity? Because then that will be contested in the court in years to come, to show that this person did not have the mental capacity. She changed the will, Your Honor, when dad really intended that it was supposed to be given to me and my older brother, but he subsequently changed it just to give it to his stepdaughter. So and then the doctors are called in for cross-examination, so on and so forth. So to avoid all that, we always make sure, if we find that someone's mental capacity is questionable, I always request for a doctor certificate to confirm that the mental capacity is in fact all okay. And then we explain to them the legal effect of the will, and mostly everyone knows what it's all about. It's not the good old days where people don't know, they don't understand where their assets are and all that. You should have 2 witnesses sign your will, which is very, very, very important. There should be 2 independent witnesses, because otherwise a will does not become a valid legal document. And we've touched on mental illness, and also, for example, the other thing that people usually fall into of late is, for example, you might have a carer coming to your home, or you might have a cleaning lady coming, and you might say, oh, you're so beautiful, Tara, this is so lovely, you're amazing. you know what, you know, when I die, you're going to get something. So trust me, you will get something. You've been looking after me and my wife so well. And I want to make sure that we take care of you after we pass away. So we will leave something for you. If you say something to that effect to anyone, or if you actually have misled, or you don't, obviously you don't have the intention to mislead, that's not the word. I would say if you actually have led anyone to believe that you would give them something when you pass away, then they have a right to bring a claim under what is known as family provisions claim, saying that you've led them to believe you would leave something for them once you pass away. And they can bring that claim within a year to the Supreme Court and then say that that should be given to them. They should have some part of the estate given to them because you promised to them once when they, you know, so-and-so said to me in words to the effect of, oh, don't worry, Tara, you will get something when I pass away. People don't realize that, you know, you say it, maybe thinking that you'll be giving them 10 saris, or maybe thinking that I'll give them a jewelry set or something. But, you know, it can be totally misconstrued, and we're talking about days in Supreme Court arguing about it, and they could walk away with hundreds and thousands of dollars from your estate. You should make sure that if you actually have made any reference to that point, you can always go back and change your will if that's not a problem at all, but make sure you cover it. And even if on that topic, let me also touch, because in a way we have people come in and say, look, I don't want to be giving anything to my middle son because my relationship with him is finished. I don't want anything because I've considered him to be gone, and when they go on. I always advise them to leave something for them, because if you do not leave something for all your children, even if it's a very normal amount compared to the other children, that son or daughter can bring a claim against the estate in the future, saying that I was left out of the will and I need a portion of my dad's or mom's estate because I am also one of the siblings. I was left out, which was not at all intentional. And then we're again talking about weeks of arguments in court. So even if it's an estranged wife or estranged child, please leave something for them in the will, because otherwise it can be contested in years to come. Will, once it's done, where do you need to be keeping it? This is good old days where people write a will, keep it in a drawer, no one knows about it, and then everyone's searching for it when something happens. In this day and age, obviously, what we say is once you sign it, please have it scanned. Please send a copy to your executors and all your children, because you know it's all there. If you want the children to know, of course, not everyone wants the children to know about it, but otherwise, definitely give a copy to your executor and give a copy to your lawyer and accountant, and store the original in a safe place, because you definitely need the original. Keep it in a safe place. Let them know where it is kept. You can leave it with your lawyer, accountant, if that is your choice, or leave it in a safe place and tell your executor where it's kept. It's very important, because otherwise, you know, when it comes to handing over the original to the Supreme Court, everyone's running around to figure out where the original is. So it's very, very, very important. Okay, moving on to the assets in India. Another issue that I always get faced with by clients is, oh, I've got property in India, I've got bank accounts, I've got assets. I want to consolidate it all when I'm doing a will. My recommendation is a big no. Please do not do a will which encapsulates all assets all over the world, because it is a headache for your children. It will take them at least good 2 years to get property in Australia released, minimum 2 years, because you know nothing happens in India in a jiffy. We all know that, unfortunately. So people have to physically go there, physically get the bank account closed, physically do the sign off, this umpteen paperwork that is and drawn in, like anything to do with India. I'm only touching India at the moment because I'm assuming most of us are from India. And so, yeah, it is a Herculean task, and children these days don't have the time, and they'll say, oh, I can't be bothered to go look for this asset there, or even the bank account. I've got many people telling me, I don't want it. Can I just have this formalized and finalized, the probate issued out of Australia, which means that they're letting go of the property in India, because they do not have the time to take a month off, go there, get that sorted, and come back. So obviously, the best would be to dissipate all the assets while you can and have it all left in one country, so that it makes life a lot easier for your children. But obviously, it's easier said than done. I realize that you can't, or not everyone can do that. If you have got assets left in India, please do a separate will in India or any other country, so that the assets are kept separate. You have complete distinction between the two different countries. You do not mix match it, so that the executor here knows he or she's only dealing with assets in Australia, and executor in India knows that's separate, so it does not get entangled. So that's very, very important, and for time management as well, because everyone's waiting to get their asset fair share of the asset estate and move on with their lives. So no one wants to get drawn into this elongated process. I know I'm running out of time, so I'm just going to skip through a few things and then make sure that we touch on everything important. We've spoken about bank accounts, assets located or co-located. So yeah, please do keep two separate accounts two separate wills. That's what I would strongly recommend. Power of attorney. Again, this is a terminology that I'm sure all of you would have come across during your lifetime at one point or the other. Power of attorney is a formal document that you are authorizing a person to act as your attorney to the world out there. And that is what it is. Simple. It's nothing more complicated than that. So for example, if you want to be selling a property in India and you want to authorize your brother-in-law or brother in India to be selling their property on your behalf, you have to sign and send a release, or a document authorizing him to be an attorney in India to act on your behalf and sell the property for you. So it's a document that is saying, yes, I authorize Mr. So-and-so, my brother in India, to be acting on my behalf to sell that. You can either identify that action, which is to sell that property, or you can leave it broad. I always recommend to make sure that it is for that specific action, because otherwise you're leaving an open power of attorney. So they can go get your bank accounts there in India. They can go do so many other things with whatever other assets. So if it's a specific, action that you want them to be undertaking, specify that. Put it between a period. So for example, if you're going for a world trip for a year, put between that period. I will be traveling between, not that it's going to happen anytime soon, unfortunately, because of COVID, but if, let's say, I'll be traveling between Jan 2021 to December 2021. So I authorize my brother to take care of all my financial requirements in India in relation to meeting all, financial needs for our mom. So he's authorized to take care of all the bank accounts, blah, 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 for this time. Specify that, and so that it's locked in. It's not an open-ended document. So that's something that I specifically request for people to do. And also, when people are actually trying to sell properties, anything to do with property in India, it's again another Herculean task. What I recommend, because whatever we prepare and send from here, they're never happy with the documents there, because each municipality or township or panchayat or whatever we're talking about in different parts of India vary from one corner to the other of India. So what I recommend is, whoever the real estate agent they are dealing with, please ask the real estate agent to get a power of attorney or in an Aadhaar document, because they want everything done in the stamp duty paper. Get that prepared from there, send it in a registered post here. You will get that here. You meet then a notary, not a solicitor, not a JP. You meet a notary who notarizes the document. That is another big distinction that I always find myself telling people. Please meet a notary, which you can Google and find whoever your closest notary is. You pay them $250 or something like that, $250 or dollars, get that notarized. They put a red seal and stuff. You then send that original back to India. And that is what is actually a valid document, so that there's no further confusion. So general power of attorney is where you actually specify the term. Enduring power of attorney is that goes on for a lifelong period, which I usually don't recommend for people to do. We've spoken about that. And also when an action finishes, for example, if you've left things open and you want to put an end to that, you can always bring an end to a power of attorney and say that it no longer is applicable. I bring an end to this document. Power of attorney, again, we've touched base. If it's anything to do with land in Australia, for example, if you're traveling and you've got a settlement happening, you bought a new property, investment property, and you're authorizing your daughter to be a power of attorney to finish off the conveyancing or whatever, to sign off on documents and all that, we have to have that registered in the land titles office. And there is a registration fee for that in Australia, which is $105.50, which anyone will take you through. So that's not a big issue. Guardianship, again, I'll touch that very quickly so that everyone's aware of what exactly are we talking about. Again, most of the doctors would know what guardianship is all about. We, again, find ourselves in a situation where our clients, kids come to us saying that, mom is losing her cognitive skills. We find her issuing checks to cleaning ladies and carers and people are coming and taking money out of her left, right, and center. I do not feel comfortable. So can I have her financial management changed over to me? Or can I? And mom will say, no, nothing wrong with me. I'm totally fine. I don't know why she's telling me or telling you all this, because I'm totally fine. I don't have any issues. So then we ask them to lodge an application with the Guardianship Tribunal. There's New South Wales Guardianship Tribunal, where you can appoint, like a request for a guardian to be appointed. And obviously, tribunal takes that very seriously, because it's obviously stepping into someone's life that we're talking about, because that person is saying, look, I'm totally fine. And the children are saying, no, mom has lost it. We are worried for her. She's giving money left, right, and center. She's going shopping. She's forgetting what she shopped on the previous day. She's actually giving away tens and thousands of dollars to the neighbor when they came and asked for money, because she doesn't actually remember what's exactly happening. So financial management can be given to someone if that is what the situation is, because if she's okay to take care of her health, that's fine. Financial manager is appointed in that situation, and that can be family members or an independent person through the Guardianship Tribunal. Whoever, not everyone will have family members around, so an independent person can be appointed. Or if you're talking about someone's well-being and health-related issues, or in relation to someone's refusing medications, not going to the doctors, you can see that your neighbor is actually running down, total rundown within a 4-week spans that you've seen. So you're going, something is amiss here. I need to make sure a guardian is appointed for his or her well-being. I'm going to be going to do that for her, because she doesn't know, I don't think she is with it. So then you can apply to the New South Wales Guardian and say, look, something is going wrong here. Can someone look into it? I'm just an interested person to make sure that her well-being is taken care of. Someone will come and take care of. They look into it. They'll ensure that a doctor comes and sees her. They look into her financial assets, make sure that your concerns are taken care of, addressed, and if the need warrants it, then they'll definitely appoint a guardian. And obviously, as I said, it can be a family member, and it can request for any independent party to be appointed as well. It's mainly to make sure that people are taken care of, and especially when they are not with it in the right frame, to make decisions in relation to their health or financial issues, or their day-to-day living issues as well. I am running out of time, so unless Vijendra Auntie,
it's okay, Mitu. You can have you can continue, please. I think there's not a problem with the time.
Okay, thank you. So elder abuse, again, we have been contacted of late, and I'm seeing it a bit more of late. I think it's more because people are becoming more technologically advanced, the elders. So it's getting a little easier as opposed to the good old days where they could not actually reach out to people, because they had to be physically taken to a lawyer, or physically taken to a place where they could open up. These days we do get emails overnight basically saying, look, this is what it is. This is my situation. I'm not getting money. And if this is where I am, everything has been taken care of. I'm asked to cook all the time. I'm pretty much like a maid. Or we've got sad situations where people are being physically abused as well, and which is where we escalated further, and then obviously tell them to notify the police. And it gets things do get bad and ugly, which is very unfortunate. But there are situations where that has been the case, and these are the different kind of abuse that we're talking about: psychological abuse, physical abuse, neglect, financial abuse, and sexual abuse. The majority, obviously, that I've come across relates to financial abuse, because everyone needs money. And, unfortunately, once the money is taken out of the parent or the elderly person, then they're not looked after, or the promises are not kept. And which is what the Asha videos actually had touched in depth, and which is why I think it's an amazing video, both of them. So please do pass it around, and the community should be made more and more aware of it. To ensure, and then this ties back into what we were talking before. If you plan your assets really well, if you ensure that your assets are well protected, and your kids know that you're not going to be dilly-dallying and getting swayed and pressurized in doing that, and then for sure the elder abuse will not be followed through. It's unfortunate. It's one that actually follows through with the next, because if you can see the pattern, the kids start to work on the parents, they'll bring the parents in to change their will, and then itself it's red light starts to sort of show up, and 5 years, 6 years down the track is when the parents starts to ring us and say, look, things have changed. I'm dumped in a nursing home. I don't have anything here and I don't have any contact. I've been taken away. I've been pretty much robbed of everything that I have. So what can I do? What are my rights and how can I take this further? So I think if you actually plan things properly, if you actually have things in a watertight situation to begin with, you will not be, your chances, I can't guarantee, but the chances of the elder abuse situation being subsequently being faced is reduced, because obviously if you are financially stable, just like how things were when it's when someone's young and if they're going through domestic violence, but if they're financially stable and if they're financially independent, things are totally different as opposed to a mother who's been abused all the way. And she's a young mother, she's got 2 kids, and she doesn't know where to go because she doesn't have a choice but to put up and shut up because financially she's not in a position to walk out of her home. Exactly like that. Fast forward 40, 50 years down the track. If there is money, then you have the confidence, you can at least reach out, you know the resources to get out there to, you know that, okay, the technology is at your fingertips these days, and all of you are so amazing. You've all connected via Zoom. So everyone's quite technologically advanced these days. You can reach out, but that's because you've got the financial stability. So please make sure you've done your due diligence. We all love our kids. We all want to be leaving our assets to our children because we work hard for the next generation, in essence, definitely. But we've got to make sure we are protected before we actually leave any other doors open in any way so that it doesn't backfire against us. So that pretty much sums up what I was saying. So this elder abuser was talking about the statistics, which is very, very sad. It's mistreatment, who's at risk, and first and foremost, how to protect yourself. We've been through that. What can you do for yourself? Power of attorney, freezing bank accounts, and then those are my details, which I'll pass around. So if anyone wants to reach out to me at any stage, please do. Otherwise, if there are any questions, I'm more than happy to answer them now too. Thank you so much. And I'll just get off my screen at the moment. And then if there's, okay, so someone's asked me a question.
Can we just wait for a question to the last minute? Thank you, Mitu. There's a lot to be learned and a lot to digest. It's wonderful. Can I ask Dr. Valanju to say a vote of thanks? And then please, for the questions, put your hand up, and that means you unmute yourself. And then we can, please ask the question, because as I said, we will put Mitu's contact number on the WhatsApp groups as well, so that people can reach out. And so is Dr. Valanju there?
Yeah, I'm here.
Would you like to say a vote of thanks, please? Thank you.
That's my pleasure. As always, Mitu, you have done a wonderful job. It's a very, very difficult topic and very sensitive topic, and you have really very comprehensively tackled it, because it is a very important topic for the elderly and for the seniors. And as we can see nowadays, that there is a lot of elder abuse arising out of the neglect of this particular topic. And you have done a tremendous job explaining it very, very at length to us, which is very important. I'm sure there's going to be a few questions, and I'm sure that you're going to really satisfy all our curiosities and all our requests. So thank you very much. And we would like to get your advice from time to time, and thank you for coming to this forum, because Asha is well known for these forums, and we got a very large following, which is going to be very, very happy with what happened today. So thank you, and I'll get off this and you take over.
Can we give a big clap to Mitu, please? Can we all clap? Thank you. Now we open for questions, and please, if you have a question, make sure you unmute yourself, and there is enough time, that you don't have to worry. So do we have any questions, please?
Before that, thank you, Mr. Gopalan.
Yeah.
That was a wonderful talk. We
Oh,
really
thank you,
appreciate
Doctor.
that.
Thank you for tuning in from
Thank you.
Byron Bay.
Thank you, Dr. Sundar. Next, is there any question from anybody else, please? Padmanji.
Hi, Mitu, how are you?
Hi, Vapeta. How are you? Good
Good,
evening.
thank you. Mitu, a simple question is, you mentioned about the second, you mentioned about having a second executor as well. So rather than that, can we have joint executors? Say, for example, I have 3 sons. Can I have all 3 of them as?
You have to unmute, Padmanji. Unmute, please.
Oh,
Yeah,
right.
thank
Okay,
you. Yeah, that's okay.
Okay. Repeating the question. So instead of having a second executor, can I have joint executors?
Absolutely. As long as you know your children, if they all get along really well, perfect. If otherwise, it would actually delay the process, because the whole point is all of them to be taking a decision cohesively, jointly, in a timely manner, rather than creating more issues. So yeah, it's up to you. If definitely you can do it, to answer your question, Papeta, but if there's any issues that you foresee, then definitely not.
Okay.
Thank you.
Can I
Vinodji
have-
has got a question.
Okay, thank you.
Sorry.
Thank you. Yeah.
Thank you.
Hello, Mithu.
Oh.
Very informative talk.
Thank you,
Just
Vinodji.
just
Thank you so
a
much.
curious question. If there are 2 executors
Right.
and if they have opposing views, which executor will be utilized?
Okay, so for example, if we are talking about the situation that Papeta was talking about, so if there are 3 sons trying to say, look, I want to sell this property, I don't want to sell this property. Obviously, the third one will say yes or no, which makes life easy when it's 3. But if there are 4 executors, and if 3 actually say 2 says the same thing and the 2 says another thing, then it becomes hard. Whereas if it's one family member as opposed to a non-family member, then obviously the non-family member will give a very independent, prudent view, because he or she has nothing to gain from it. They'll say, look, the property I think should be held off till COVID is finished, because the market is really low at the moment. So I would strongly recommend, this is a report that says that, which will come, the bubble will be back, we'll be back out of the bubble by February 2021, hold off. So it's brains versus, there's a independent evaluated decision whenever there's a second person who is a professional. That's why I always recommend to have a separate non-family member as a second executor, so that can be avoided. That very issue can be avoided in OG.
Thank you.
Thank you, Mithu. We got any other question, please?
Yeah, my husband wants to ask a question.
Husbandji, come over and ask the question, please, Surinderji. Kamini's husband's turn, please.
Mithuji, congratulations for a very good setup and a very good knowledge given to us. I'm the only husband for us, so that you just mentioned.
That's good to hear.
My question is very simple and very short. Are there some different notaries in Australia who are dealing with the overseas?
Okay,
Or
so
any notary can do?
Any notary can do. They all have to qualify an exam here. So any notary can do. So what I recommend to my clients is just do a Google search. There are a lot of notaries around everyone's suburb. So you find someone who's local. Previously, we used to have to go to the Indian consulate to get it notarized. That used to be the old way of doing it. So any document sent from India, we usually tell our clients to go to the Indian consulate and to have it notarized there. But gone are those days. It's all stopped when the visa, the visa requirements, everything, they detach themselves from everything else, the consulate. So now we tell people to go find an independent notary, and all notaries in Australia have to pass an exam. They're all the same. We just have to make sure we find one. As soon as you find one, pay their fee, they'll get it notarized for you.
I have this because in 2004, I had to notarize the papers, and the papers came from India.
Right.
He said that on Indian stamp, I will not do it.
That's
This
that's
is the
way a while
notary
ago.
in Chatswood.
Right, that's a while ago. Things have changed now. So an
Okay.
Indian, we have every client getting all the power of attorney coming from in that Indian stamp paper, that is very mandatory there in India. So they courier it here, clients get it. I can't notarize, I can't witness it or notarize it because I'm a solicitor and I'm not a notary. So then we
Yeah.
send them off to a notary, they notarize it, they do it, and then they immediately courier it back to India. So
Mitu, I have used the notary. I have used it when I was selling the house. The Google search, they're close to in the North Shore,
Okay.
and it is recognized. They do charge a fee, but
Yes.
I mean, from my past experience, you can, even if they send the paper, but you can have it made it here, and
Yes.
that was recognized.
So maybe it's because it's a little, in 2003, 2004 time, things were a little different, Uncle, but now it's all streamlined.
Like in India, they have got a different status.
Yes.
Now, in India, if you do something, they have got a special people who can attest your papers, you can send your papers. Everybody can't do for the overseas.
Exactly. But here it's different. There is an exam that you have to pass, and that's how you become a notary. And so you don't have to be a solicitor to be a notary. You can apply for the exam too. And you can sit for the exam. You can be a notary. It's like a JP. Anyone can become a JP. There's no course apart from certain paperwork to be processed and qualified for. Obviously, there are requirements, but it's not a course.
Mitu, can I ask you to clarify between the power of attorney, the way we look in India is that we give somebody the authority to take care of our affairs. Mostly it's the financial, but power of attorney here is that enduring other one is a bit different. When I made the estate planning, to me it was in case I wasn't able to decide what, like I'm not in a capacity.
Enduring power of attorney, and you're right. There are two different things. One is power
So
of
can we
attorney
clarify?
Sure. Thank you. So power of attorney is a document where you're authorizing someone to do a particular act for you. So to the world, you're appointing me, for example, Bijendra Aunty appoints me to be the attorney in relation to a conveyancing matter because she's got to suddenly leave for overseas. I take care of all that. By the time she comes back, she's got the property, but the property is still in her name. I'm just doing all her paperwork on her behalf. So I've just won that on behalf of Bijendra Aunty. Enduring power of attorney is, for example, you find that your wife or your husband is actually becoming seriously ill. Like someone's got cancer and suddenly someone's deteriorating. People come to us saying, look, we've got things to take care of and to make sure that we don't know how soon the person will deteriorate. So that person is actually giving me the authority to be her pretty much like attorney for all purposes to make life decisions in relation to health. Like, for example, if he or she doesn't want her life support to be turned on after 2 days, all that. Like, we always hear, oh, my life support has been turned off. Who has the right to do all that? It's when you have an enduring power of attorney given to someone. So that person can then say to the world, yep, these medications are okay, I agree with that. Or no, the person did not want his or her body parts to be given in any way. She specifically told me, no, she doesn't want this treatment. After a week 1 or week 2, she doesn't want to be going further. Life support to be turned off after 2 days. That's what an enduring power of attorney document helps that person to have the right. And again, that stops the minute when someone passes away and the will kicks in when someone dies. So that's the difference. So with the enduring power of attorney, you cannot do anything further after that person passes away. It's your right to actually make decisions on behalf of that person until that person passes away. And that's usually when someone's actually really, sudden deterioration happening and sudden decision-making skills being affected in some way. Then yes, they do come to us to have the enduring power of attorney to be drafted into. So yeah, thank you for raising the question.
Thank you, Mitu. I just thought it's better to clarify because in India, it was power of attorney was very different than what we say enduring. Mangaji has got a question.
Enduring power of attorney, how important it is? Enduring power of attorney.
I wouldn't recommend, some people say, no, we want to get it done. We want everything to be done so that there's no confusion. But if you're healthy and well and everything is going good, and especially if you've got a supporting family and all that, you're really not looking into it, but it really depends on your particular scenario. So I can't say, give a specific advice unless I know exactly what your specific scenario is. For example, if you've got a partner, if you've got a wife, if you've got children who are there to take care of you, if you're living by yourself alone, or if you know that something's happening to you, then that's when the enduring power of attorney is actually recommended. Otherwise, no.
Thanks. Yeah.
Dr. Sundar had a question. Dr. Sundar?
Sure, doctor.
Thank you.
Just a small question, Mr. Gopal. I always recommend my patients who are 7, 8 years old to have a power of attorney and a guardianship in case they need to go to nursing home. Is that a good idea?
Definitely. I would strongly recommend enduring power of attorney. If you believe that, they are actually slowly, losing their cognitive skills and, they need help bit by bit by bit, then yeah, definitely have an enduring power of attorney. Guardianship is when you're appointing someone, that person is resisting and someone else is saying, can I please step into your shoes to take care of your affairs because I think you're losing it. And that person is saying, no, everything is okay with me. I don't want it. So in your case, doctor, it would be enduring power of attorney. Its guardianship kicks in when someone is opposing. So you're going to the New South Wales Guardianship Tribunal, requesting them to make an order for someone to take care of their affairs. You're saying, I'm really worried about my mother or my dad. My step brother is really looting him. I can see that. And, he's slowly losing it. He's not with it. I want an independent person. I don't care whether it's me, but I want someone to be appointed as his guardian to make sure that doesn't happen in the future. So,
the reason why I'm asking is I got 10 patients under guardianship now in the nursing home.
Right.
Every time I had medication, I need to ask the permission from the Attorney General. Then they should say yes or no.
It is a very, very convoluted process because, they want to make sure everyone's working in the best interest of that person. So on one hand, I take my hats off to them because I'm thinking we are so privileged to be living in a country like Australia, where the system and the medical facilities and the health system is so caring that they want to make sure that people are not taken advantage of. Even when someone's 78, 82, 85, they want to make sure that the person is protected in every way. So for example, when you prescribe medication, doctor, they have it insured and reticked by someone else to ensure that these are not medications that are overly prescribed or this is something that this person needs. So I think it's an amazing thing that Australia has that, I always look at the amount of resources that they actually throw into all this. And we're very privileged and blessed to be in a country like Australia for sure.
Thank you, my Ashirwad.
Any other questions? Do we have any other questions? Vinodji's got another question.
Yeah, just to clarify.
Sure, Vinodji.
I suppose if someone gives guardianship to someone, that will be almost irreversible process. Like that person who has given the guardianship will not be able to change his or her mind, isn't it?
Great point, Vinodji. But again, guardianship, you don't give voluntarily. Enduring power of attorney, you give someone the authority voluntarily. So guardianship, as we were talking about, we have to go to the tribunal to get an order to ensure that so-and-so is appointed as a guardian. Again, another great thing, leading to what I was saying before, they're very good. They only give a guardianship order for a prescribed time period. So then every year, 6 months, depending on the situation, how bad the situation or how good the situation is, they'll give it for a year or 2 years and then say, come back to the tribunal to show that everything is working properly. We want to know, you've got to account back to us in 2 years' time. And if everyone else is complaining, then we're going to change you. So you have the peace of mind that this person is not going to be ripped off. Okay. So that's also a blessing. So the way the New South Wales Guardianship and Trustee Tribunal actually takes care of people and the interests of the people and the well-being of the elderly is just amazing. I take my hats off to them, actually, apart from all other entities. I'm not discrediting any other entities, but that is another avenue that we are blessed to receive in Australia, I think. But thank you for raising the question, Vinodji. That was an interesting point. Thank you.
Do we have any other questions? If not, then I think that was really, really very, very informative. And I hope that our members can contact. We are in the process of trying to make a list of the doctors and the other sporting lawyers and all. So we'll be contacting them and making a list very soon. And we do appreciate because...
Sorry, Auntie, I've got a question here in the chat box. Can I address that too, please?
Yes, sure.
Okay, yeah. There is a question raised by someone. It says it's private, so I don't know their name. It says Galaxy Tab A. Is it valid to have 2 separate wills for 2 countries? Yes. you only have to nominate, or sorry, you need to notify the person who's preparing the will here in Australia and will in India to say that there are two separate wills. So then whenever this will is uplifted, when someone passes away, it clearly says, yep, please go check for another will who is left with this lawyer or somewhere in India. And there is another sister will that has to be followed through as well. So yes, it is valid. And one other thing I would like to touch upon is, even if most of you said that you've made your wills, which is great, but if you want to make a change and you can't be bothered to change the whole thing and it's all a headache,